Okay, continuing on with Cracking the Code 3rd edition, we're in the glossary, starting with the C's. Capacity. Legal capacity is the attribute of a person who can acquire new rights or transfer rights or assume duties according to the mere dictates of his own will, as manifested in juristic acts, without any restraint or hindrance arising from his status or legal condition. Ability, qualification, legal power, or right. Applied in this sense to the attribute of persons, natural or artificial, growing out of their status or juristic condition, which enables them to perform civil acts, as capacity to hold lands, capacity to devise, etc. Blacks first. Capital letter. So capital of letters of the large sized used in the beginning of a sentence or as the first letter of a proper noun. So that's from ACD. Note, names written in all capital letters are artificially constructed names of the artificial persons. See all caps letters written proper. All right, cash proceeds. Cash proceeds means proceeds that are money, checks, deposit accounts, or the like. UCC 9-102A9. Census. The official counting or enumeration of the people of a state or nation with the statistics of wealth, commerce, education, etc. In Roman law, a numbering or enrollment of the people with a valuation of their fortunes. Blacks first. See note census regalis taxpayer. Note, the first definition is modern. So the first definition above does not preclude the second, that is the ancient. Please note that the UCC filing offices operate in the private realm and that the filings therein are not contingent upon the provisions of identifying serial numbers such as Social Security account numbers. Census regalis. The royal property or revenue. Bouvier's 8th. Certificate. A document in which a fact is formally attested. Black 7th. A written assurance or official representation that some act has or has not been done, or some event occurred, or some legal formality complied with. Blacks first. Certificate of title. Certificate of title means a certificate of a title with respect to which a statute provides for the security interest in question to be indicated on the certificate as a condition or result of the security interests obtaining priority over the rights of a lien creditor with respect to the collateral. UCC 9-102A10. Certified clerk. See acceptance of draft. Sestu or sestue. Sestui. Hebrew? Used frequently in composition and law, French phrases. Okay, here we go. Sestike trust. Seti or sestui or key. One who possesses equitable rights and property and receives the rents, issues, and profits from it. So a beneficiary, Black 7th. He who has a right to the beneficial interest in and out of an estate, the legal title to which is vested in another. The person who possesses the equitable right to property and receives the rents, issues, and profits thereof, the legal estate of which is vested in a trustee. Blacks first. Note, sestike trust is French for literally he that trusts. In particular species of trust is known, so this particular species of trust is known as the constructive trust and is constructed by the operation of law or fiat. Such a trust is really only the appearance of a trust. That is to say, it only looks as if it is a trust, but has no creator, truster, grantor, or settler, the flesh and blood party normally responsible for bringing a trust into existence. Per corpus juris secundum, every government is a constructive trust, concerning which Black's Fifth states, quote, a trust raised by construction of law or arising by operation of law as distinguished by an express trust. Constructive trusts do not arise by agreement or from intention, but by operation of law and not or by operation of law and fraud, active or constructive. Okay. The U.S. government creates by operation of its, quote, law the colorable cestui trust and is as the creator or constructor of the trust, the non-flesh and blood owner thereof. Every corporate entity, such as your strawman trade name, has two diametrically opposite kinds of status concerning this trust. Every citizen of the United States is simultaneously a co-trustee and co-beneficiary by operation of law. As co-trustee, your strawman has duties and obligations such as paying taxes, obeying laws, and obtaining a license for almost every normal activity of life. As co-beneficiary, your juristic person strawman has benefits, privileges, and opportunities such as welfare, protection of the state, free delivery of mail, and use of the courts, etc. In court, the judge acts as executioner or executor administrator of the trust, managing the estates of the people who functions as persons through the all capital letters juristic trade name. Okay, let's read that again. In court, the judge acts as executor administrator of the trust, managing the estates of the people who function as persons through the all capital letters juristic trade names, existing as fictitious entities under limited liability. Through a court proceeding, the judge decides which corporate debtor entity owes which other corporate creditor entity what money specific performance, thereby constructing the terms of the constructive trust on the spot. The strawman is a non-living and therefore, quotes, dead entity, and as a citizen of the United States, based on the 1933 U.S. bankruptcy, also civilly dead in law. That is to say, no standing in law and is insolvent. Such persons are thereby completely foreclosed from accessing substance, law, and sovereignty, and can possess only government-granted limited liability privileges, for example, a driving privilege. Cestui use. The person whose use and benefit property is being held by another, who holds legal title to the property, Black Seventh, he for whose use and benefit lands and tenements are held by another, the cestui use, has the right to receive the profits and benefits of the estate, but the legal title and possession as well as the duty of defending the same reside in another. CFR, see Code of Federal Regulations. Chapter 11, Reorganization. In addition to voluntarily, let's go Chapter 11, Reorganization. In addition to voluntarily and involuntary proceedings in which a debtor is adjudged bankrupt, under Chapter 11, a debtor is permitted to postpone all payments on debts so that he can reorganize his business, while other bankruptcy proceedings seek to have the debtor's assets sold and to have all the creditors paid at the extent possible. Chapter 11 seeks to give the debtor a breathing spell with the hope that his business will recover and all his creditors will be fully repaid. Barron's third. Mr. Speaker, we are now here in Chapter 11. Members of Congress are official trustees presiding over the greatest reorganization in world history, the U.S. government. James A. Traficant, Jr., Congressional Record, March 17, 1993, Volume 33. See Note, Bankruptcy. Note: the U.S. government, also known as United States Incorporated, also known as Washington, D.C., is legally bankrupt and in Chapter 11 reorganization. The Secretary of the Treasury is the receiver in bankruptcy reorganization plan number 26, 1950, 5 U.S.C.A. 903, Public Law 94-564. Legislative History, page 5967. Okay. So the Secretary of Treasury is the receiver in bankruptcy and runs the corporation on behalf of the creditor, the Federal Reserve. Okay. Charge. To load a wagon. Okay, verb. To impose a burden, obligation, or lien to create a claim against property. To claim, to demand, to instruct a jury on matters of law. Noun. In general, an encumbrance, lien or burden, an obligation or duty, a liability, an accusation. In contracts, an obligation binding him who enters into it, which may be removed or taken away by a discharge. Okay, chargeback. The action of a bank in debiting or otherwise revoking a credit given to a customer's account, which credit usually has been given for the check deposited in the account. Okay, with a dash, chargeback. A collecting bank has a security interest in an item and has accompanying documents for the proceeds of either. 2. In case of an item for which it has given credit available for withdrawal as of right, to the extent of credit given, whether or not the credit is drawn upon or there is a right of chargeback. UCC 4-210A2. Moving on, chattel. An article of personal property. Any species of property not amounting to a freehold or fee in land. The term chattels is a more comprehensive one than goods, as it includes animate as well as inanimate property. Blacks first. Chattel mortgage. An absolute pledge to become an absolute interest if not redeemed at a fixed time. Bouvière's 8th. Chattel paper. Chattel paper means a record or records that evidence both a monetary obligation and a security interest in specific goods, a security interest in specific goods and software used in the goods, a security interest in specific goods and license of software used in the goods, a lease of specific goods, or a lease of specific goods and license of software used in the goods. In this paragraph, monetary obligation means a monetary obligation secured by the goods or owed under a lease of the goods and includes a monetary obligation which are with respect to software used in the goods. The term does not include 1. Charters or other contracts involving the use or hire of a vessel, or 2. Records that evidence a right to payment arising out of the use of the credit or charge card, or information contained on or for use with the card. If a transaction is evidenced by records that include an instrument or series of instruments, the group of records taken together constitutes chattel paper. UCC 9-102A11. Citizen in American law, one of the sovereign people, a constituent member of the sovereignty synonymous with the people. Scott versus Sanford, 19. Yeah, you can read it there. Citizens are members of a political community who, in their associated capacity, have established or submitted themselves to the dominion of a government for the promotion of their general welfare and the protection of their individual as well as collective rights. Black 6th. Moving on. Civil law. Oh, here we go. Civil law, that body of law which every particular nation, commonwealth, or city has established peculiarly for itself. More properly called municipal law, to distinguish it from the law of nature and from international law. Okay, so civil law is more properly called municipal law. The system of jurisprudence held and administered in the Roman Empire, particularly as set forth in the compilation of Justinian and his successors, comprising the institutes, codes, digest, and novels, and collectively denominated the Corpus Juris Civilis, as distinguished from the common law of England and canon law, Black 6th. Okay, so civil law is municipal law, which is different from law of nature and from international law. Okay. All right, moving on. Claim. A challenge of property or ownership of a thing which is wrongfully withheld to demands as one's own to assert a right or title, Black 4th. A claim is a dispute over title, most fundamentally concerning who holds the legal title to your trade name. The holder of legal title to your trade name is the master and creditor. Your strawman is the slave and debtor. You must reclaim and reunite right and title to our strawman in order to dissolve the bonds of indentured servitude. The subject or citizen is the strawman. You are the sovereign. Per the UCC, acquiring rights evidences value. You acquire rights to the title of your strawman at the moment of his birth. Here we go. Clearfield Trust Doctrine. Governments descend to the level of a mere private corporation and take on the characteristics of a mere private citizen, where private corporate commercial paper, that is to say something like Federal Reserve notes, and securities, that is checks, is concerned. For purposes of suit, such corporations and individuals are regarded as entities entirely separate from government. Stare decisis, Latin, to stand by things decided. The doctrine of precedent, under which it is necessary for the court to follow earlier judicial decisions when the same point arises again in litigation. Black 7th. All right, moving on. Client. A client is one who applies to a lawyer or counselor for advice and direction in the question of law, or commits his cause to his management in presenting a claim or defending against a suit in a court of justice. One who retains the attorney is responsible to him for his fees, and to whom the attorney is responsible for the management of the suit. One who communicates fact to an attorney expecting professional advice. Clients are also called wards of the court in regard to the relationship with their attorneys. Corpus Juris Secundum, 1980, Section 4. See note, attorney and client. Note, clients are, quotes, ward of the courts, unquote. As to say, infants and persons of unsound mind. The scarecrow straw man in the Wizard of Oz was a person of unsound mind. Interesting. Okay. Code. A system used for brevity or secrecy of communication, in which arbitrarily chosen words, letters, or symbols are assigned definite meanings. Webster's, a collection, compendium, or revision of laws. A complete system of positive law, scientifically arranged and promulgated by legislative authority. Black's Fourth. Note, all law today is code, and such must be deciphered and decoded. Code of Federal Regulations, CFR. Code of Federal Regulations. The annual of executive agency regulations published in the Daily Federal Register, combined with previously issued regulations that are still in effect. Abbreviation CFR, Black's 7th. Code of Hammurabi, the oldest known written legal code, produced in Mesopotamia during the rule of Hammurabi, who reigned from 1792 to 1750 BC. Black's 7th, a king of Babylon who expanded his kingdom into the first great Babylonian empire. He also established one of the earliest written collections of law. Hammurabi based his code of laws on older collections of Sumerian and Akkadian laws, which he revised and expanded. One principle of the Code of Hammurabi is that the strong shall not oppress the weak. This code begins with a prologue introduction celebrating Hammurabi's military victories. He promises to treat conquered peoples justly and says he honors their gods. The provisions of the code cover many legal matters, including false accusations, witchcraft, military service, land and business regulations, family laws, tariffs, wages, trades, loans, and debts, and whatever else. The World Book Encyclopedia, year 2000. Collateral. Collateral means the property subject to a security interest or agricultural lien. The term includes all of the following. A. Proceeds to which a security interest attaches. B. Accounts, chattel paper, payment intangibles, and promissory notes that have been sold. C. Goods that are the subject of a consignment. UCC 9-102A12. Anything that is used to guarantee the payment of a loan or the fulfillment of some other obligation. Alright, C note. The property subject to a security interest, the collateral, is your trade name, and by implication, your body, labor, and property. Your birth certificate is chattel paper, a security. Accounts does not exclude Social Security account numbers, the SSANs. The U.S. government has a legal security interest in both your trade name and your Social Security account numbers. Color, semblance, disguise. Color is often used to distinguish or designate the hiding of a set of facts behind a sham, taking advantage of the confidence by technically proper legal theory or legal right. Barron's Third. Color of law. The appearance or semblance without the substance of legal right. Misuse of power possessed by virtue of state law and made possible only because wrongdoer is clothed with authority of state is action taken under color of law. Colorable law, that which is in appearance only, and not, in reality, what it purports to be, hence counterfeit, feigned, having the appearance of truth, Black's fifth. In the law of trademarks, this phrase denotes such a close or ingenious imitation as to be calculated to deceive ordinary persons. Note, colorable equals phony. Alright, moving along. Commerce. Equivalent to commerce, commerciary, to trade together. Alright, here we go. The exchange of, commerce is the exchange of goods, productions, or property of any kind, the buying, selling, and exchanging of articles, the transportation of persons or property by land, water, and air. The various agreements which have for their object facilitating the exchange of the products of the earth or the industry of man with an intent to realize a profit. Black's first edition. An interchange of goods or commodities, especially on a large scale between different countries, as foreign commerce, or different parts of the same country, domestic commerce. Commerce, or sexual intercourse, Webster's. Okay. Commerce is a term of the largest import. It comprehends intercourse for the purposes of trade in any and all forms, including the transportation, purpose, sale, and exchange of commodities between the citizens of our country and the citizens or subjects of other countries, and between the citizens of different states. The power to regulate it embraces all the instruments by which such commerce may be conducted. Black's first. The exchange of goods, production, and property of any kind, the buying, selling, and exchanging of articles, intercourse by the way of trade and traffic between different peoples or states, including not only the purchase, sale, and exchange of commodities, but also the instrumentalities and agencies by which it is promoted, and the means and the appliances by which it is carried on, and the transportation of persons as well as goods, both by land and sea. Note, commerce in everyday life is the vehicle or glue, bond, tissue that holds or binds the corporate body politic, or that is society as a whole, together. Per Title 27 U.S.C. Section 7211, all crime is classified as commercial in nature. This is admiralty jurisdiction. See UCC definition of defendant in this glossary, and the item entitled prisoners, prisons, and courts, as well as the above-mentioned 27 U.S.C. 7211, under crime is commerce, in appendix for examples of this. More specifically, commerce consists of a mode of interacting, doing business, resolving disputes, etc., whereby all matters are executed under oath, certified on each party's commercial liability by sworn affidavit, and what is intended to possess the same effect as true, correct, and complete, not misleading, the truth, the whole truth, and nothing but the truth. This affidavit format is usually required in written matters such as an IRS Form 1040, an application form for a driver's license, voter registration, a Treasury Direct account, a notary's copy certification by document custodian form, and on nearly every single document upon which those in the system desire others to be bound or obligated. Such means of signing is a sworn oath, that is to say, affidavit executed under penalty of perjury, true, correct, and complete, whereas in a court setting, testimony, oral affidavit, is stated in judicial terms by being sworn to be the truth, the whole truth, and nothing but the truth, so help me God. In addition to asserting all matters under solemn oath of personal, commercial, financial, or legal liability for the validity of each and every statement, the participant must provide material evidence, as say ledgering, bookkeeping, proving the truth, validity, relevance, and verifiability of each and every particular assertion to sustain credibility. In society, commerce comes before and is more essential than a legal system and can exist independently of and function without need of legal systems. Commercial law, the non-statutory variety, is presented in the maxims 1 through 10 under maxims of commercial law. It is the economic extension of natural law in man's social world and is universal in nature. Commercial law. A phrase used to designate the whole body of substantive jurisprudence, for example, Uniform Commercial Code, Truth in Lending Act, applicable to rights, intercourse of persons engaged in commerce, trade, or mercantile pursuits. Commerce maxims of commercial law. See note. Note, commercial law is the economic extension of natural law into man's social world and deals with the fundamental principles of human interaction concerning proof of claim, that is, dispute over title, and resolution of disputes. The fundamental purpose of commercial law is to maintain the commercial harmony, integrity, and continuity of society, sometimes also stated as to maintain the peace and dignity of the state. Over the millennia, these principles have been discovered through experience and distilled and codified into 10 fundamental maxims. There is no legal issue or dispute possible which is not a function of one of these principles. The 10 maxims underlying commerce and all commercial law, including the UCC, are listed above under commerce. The UCC is a particular codification of commercial law oriented towards the contemporary legal, financial, monetary, and banking systems. The entirety of world commerce now functions in accordance with the UCC version of commercial law. Okay. Commercial tort claim. Commercial tort claim means a claim arising in tort with respect to which either of the following conditions is satisfied. A. The claimant is an organization. B. The claimant is an individual, or both of the following conditions are satisfied regarding the claims. 1. It arose in the course of the claimant's business or profession. 2. It does not include the damages arising out of personal injury to or the death of an individual. UCC 9-102A13. Alright, common law versus civil law. Okay, here's common law. So civil law was just another name for municipal law. Now here's common law. The common law is that which derives its force and authority from the universal consent and immemorial practice of the people. It has never received the sanction of the legislature by an express act, which is the criterion by which it is distinguished from the statute law. It has never been reduced to writing, but this expression, however, is not meant that all those laws are at present merely oral or communicated from former ages to the present solely by word of mouth, but that the evidence of our common law is contained in our books of reports and depends on the general practice and judicial adjudications of our courts. 2. The common law is derived from two sources: the common law of England and the practice and decisions of our own courts. In some states, the English common law has been adopted by statute. There is no general rule to ascertain what part of the English common law is valid and binding. To run the line of distinction is a subject of embarrassment to courts, and the want of it a great perplexity to the student. It may, however, be observed generally that it is binding where it has not been superseded by the Constitution of the United States, or the several states, or by their legislative enactments, or varied by custom, where it is founded in reason and consonant to the genius and manners of the people. 3. The phrase common law occurs in the 7th article of the amendments of the Constitution of the United States. It suits at common law, where the value of controversy shall not exceed $20, says that article, the right of trial by jury shall be preserved. The common law here mentioned is the common law of England and not of any particular state. The term is used in contradistinction to equity, admiralty, and maritime law. The common law of England is not in all respects to be taken as that of the United States or of the several states. Its general principles are adopted only so far as they are applicable to our situation. Bouvier 6, see note. Note, the system of jurisprudence that originated in England and was later applied in the United States and the several states, originally based on the procedures developed by free, sovereign, allodial landowners to resolve disputes over land such as borders and ownership. After the Norman conquest of 1066, common law came to be based on judicial precedent, that is, court decisions, that was increasingly absorbed into the crown. By such means, what is called common law in name became increasingly Roman civil law. True common law is completely independent of all governmental involvement. All governments are variants of Roman civil law, the law of kings, princes, and rulers. Nevertheless, common law remained based on transmitted, established principles rather than legislative enactment, that is to say, statutes, statutory laws, and codes. Great care should be used concerning the precise manner in which the term common law is defined, understood, and used. One should ascertain the implications of the word. For example, what law is common, where, and to what? Traditionally, in the absence of statutory law regarding a particular subject, the judge made rules of common law or the laws on that subject. Let's read that again. Traditionally, on the absence of statutory law regarding a particular subject, the judge made rules of common law are the laws on that subject. Okay. Thus, the traditional phrase at law refers to the state of the law in the particular field prior to the enactment of legislation in that field. Compare statute and Roman civil law. Okay. Communicate. Communicate means to do any of the following. A. To send a written or tangible record. B. To transmit a record by any means agreed upon by the person sending and receiving the record. C. In the case of transmission of a record to or by a filing office, to transmit a record by any means prescribed by filing office rules. UCC 9-102A18. Complaint. In civil practice, in those states having a code of civil procedure, the complaint is the first or initiatory pleading on the part of the plaintiff in a civil action. It corresponds to the declaration in the common law practice. In criminal law, a charge preferred before a magistrate having jurisdiction that a person named or an unknown person has committed a specified offense, with an offer to prove the fact to the end that a prosecution may be instituted. It is a technical term descriptive of proceedings before a magistrate. The complaint is an allegation made before a proper magistrate that a person has been guilty of a designated public offense. Okay. Note, a private man cannot commit a public offense. Only a public man, straw man trade name, can commit a public offense. Interesting. Conference of Governors, March 6, 1933, see note. Note: accommodation of the federal bankruptcy, whereby the governors of the 48 several states of the Union pledged their faith and credit to aid the national government, and thereafter formed numerous socialist programs such as Council of State Governments, Social Security Administration, etc., purportedly to deal with the economic emergency. They operated under the Declaration of Interdependence of January 2nd, 1937, and published some of their activities in the Book of the States, Volume 2, page 144. See in this state. All right, here we go. Constitutor. In civil law, he who promised by a simple pact to pay the debt of another, and this is always a principal obligation. Okay, see Bouvier's 8th. In the civil law, one who by simple agreement becomes responsible for the payment of another's debt. Black's first. Roman law, a person who by agreement becomes responsible for the payment of another's debt. Okay. Black's 7th. Note: when you sign a traffic ticket, you become the constitutor for the debt created by the policeman. See Senate document First Congress. Okay. When you sign a traffic ticket, you become a constitutor for the debt created by the policeman. Money is brought into existence by borrowing. The cop creates the new money by issuing a charge in his name. He signs the traffic ticket first. His intent is to transfer the debt to you as constitutor. If you adopt the role of authorized representative or agent, you incur no liability for signing because you are not signing as a principal. Signing the ticket by order of, name of cop, John Henry Doe, copyright symbol, by cursive, John Henry Doe, copyright, authorized representative for agent, leaves you without responsibility for payment performance as you are not a constitutor. Okay, see how to sign your signature without liability on page 315 in section 10 for further explanation. Cool. Constructive. That which is established by the mind of the law in its acts of construing facts, conducts, circumstances, or instruments, that which has not the character assigned to it in its own essential nature by acquires such character in consequence of the way in which it is regarded by the rule of policy of law, hence inferred, implied, made out by legal interpretation. The word legal being used sometimes in lieu of constructive. Okay. See note. Note: Corpus Juris Secundum defines a government as a constructive trust. Black's 5th defines constructive trust as a mixture of law and fraud. Today, all courts are private commercial tribunals collecting from the assets, that is to say, every citizen of the United States in Chapter 11 Reorganization and Bankruptcy of the U.S. As such, every court today is a court of general equity wherein the judge can pick and choose from any body of law on earth, informing his decision with the final basis of decision-making being the conscience of the court, meaning whatever the judge feels. All such courts are corporate contract courts, dealing with fictitious entities and contracts between them. The straw man of each disputant or party to the controversy is within the bankruptcy and the corporate U.S., which is a public trust under the 14th Amendment. Such an arrangement has only two parties, co-trustee and co-beneficiary. A public trust has no creator, trust, grantor, settler. as with an express trust, which involves 3 parties, not 2, as with a public trust. In sifting, sorting, and selecting from the law and facts of the case, a judge forms a constructive trust, in which the judge constructs the terms of the particular trust contract emerging out of the dispute. A trustee of a public trust has duties and obligations. A beneficiary receives or derives benefits from a trust. Every strawman trade name today has duties as a co-trustee along with privileges as a co-beneficiary of a public trust. Consequently, in every court case today, the judge is constructing the terms of the constructive trust to decide what strawman owes their other strawman, what recompensates specific performance. Consumer goods. Consumer goods means goods that are used or bought for use of primarily for personal, family, or household purposes. Uniform Commercial Code 9102A23. See note. Note, per this definition, an automobile used primarily for personal, family, or household purposes qualifies as consumer goods. Customer transaction. Customer transaction means a transaction in which 1. An individual incurs an obligation primarily for personal, family, or household purposes. 2. A security interest secures the obligation. And 3. The collateral is held or acquired primarily for personal, family, or household purposes. The term includes consumer goods transactions. UCC 9-102A23 or 26. Assignments of commercial deposit accounts are governed by revised Article 9. Although assignments of deposit accounts in consumer transaction remain excluded, see notes Penelope Cristoforo of Cleary, Gottlieb, Steen, and Hamilton in New York City. The definition of consumer transaction in revised Article 9 does not include a monetary component. She says, and as a result, certain pledges of deposit accounts by high net worth individuals in transactions entered into for personal, family, or household purposes would be excluded from revised Article 9's coverage, notwithstanding the size of the financing. William C. Smith, American Bar Association Journal, August 2001, page 54. See note. Note, assignment of deposit, checking, savings, passbook, time, accounts, and transactions entered into primarily for personal, family, or household purposes are not addressed in revised Article 9. Contract. An agreement between contract. An agreement between 2 or more persons which creates an obligation to do or not to do a particular thing. Its essentials are competent parties, subject matter, a legal consideration, mutuality of agreement, and mutuality of obligation, Black's Fifth. Note, all contracts, whether express or implied, are subject to the universal essentials of contract law pertaining to the fundamentals of interaction between the parties. These fundamentals are well codified in many places. For example, California's Civil Code, sections 1549, are as follows. Section 1549, contract. What? A contract is an agreement to do or not to do a certain thing. 1550, essential elements of contract. It is essential that the existence of a contract that there should be 1. Parties capable of contracting. 2. Their consent. 3. Lawful object. And 4. A sufficient cause or consideration. Section 1556. Who may contract? All persons are capable of contracting except minors, persons of unsound mind, and persons deprived of civil rights. 1565. Essentials of consent. The consent of the parties to a contract must be 1. Free, 2. Mutual, and 3. Communicated by each to the other. 1567. An apparent consent is not real or free when obtained through 1. Duress, 2. Menace, 3. Fraud, 4. Undue influence, or 5. Mistake. 1598. When contract wholly void, when a contract has but a single object, and such object is lawful, whether in whole or in part, or wholly impossible of performance, or so vaguely expressed as to be wholly unascertainable, the entire contract is void. 1608. Effect of its illegality. If any part of single consideration for one or more objects, or of several considerations for a single object, is unlawful, the entire contract is void. 1620. Express contract. What? An express contract is one, the terms of which are stated in words. 1621. Implied contract. What? An implied contract is one, the existence and terms of which are manifested by contract or by conduct. 1441. Impossible or unlawful conditions void. A condition in contract, the fulfillment of which is impossible or unlawful within the meaning of the article on the object of contracts, or which is repugnant to the nature of the interest created by the contract, is void. 1636. Contracts. How to be interpreted. A contract must be so interpreted as to give effect to the mutual intention of the parties as it is existed on the time of contracting, so far as the same is ascertainable and lawful. 1668. Certain contracts unlawful. All contracts which have their object, directly or indirectly, to exempt anyone from responsibility for his own fraud or willful injury of a person or property of another, or violation of law, whether willful or negligent, are against the policy of the law. 1709. Fraudulent deceit. One who willfully deceives another with intent to induce him or alter his position to his injury or risk is liable for any damage which he thereby suffers. All right, next one. Contribution. Contracts. When two or more persons jointly owe a debt and one is compelled to pay the whole of it, the others are bound to indemnify him for the payment of their shares. This indemnity is called a contribution. Bouvier 6. When one of several debtors pays a debt, the creditor is bound in conscience, if not by contract, to give to the party paying the debt all his remedies against the other debtors. Bouvier 6. A right to contribution exists in the case of debtors who owe a debt jointly which has been collected from one of them. Bouvier's 8th. The right that gives one of the several persons who are liable on the common debt the ability to recover ratably from each of the others when the other person discharges the debt for the benefit of all. Black 7th. War contribution. Black 7th. See War contribution, Ponzi scheme, the curse of co-suretyship in part 1 of this manual. All right. Convey. Conveyance. To transfer as property or title to property from one person to another. Corporation. An artificial person or legal entity created by or under the authority of laws of the state. An association of persons created by statute as a legal entity. The law treats the corporation itself as a person that can sue and be sued. The corporation is distinct from the individuals who comprise it, shareholders. The corporation survives the death of its investors, as the shares can usually be transferred. Black 6th. Corporation aggregate. A corporation aggregate is one composed of a number of individuals vested with corporate powers, and a corporation, as the word is used in the general popular and legal speech, and as defined as the head of this title, means corporation aggregate. Corporation sole. A corporation consisting of one person only and his successors in some particular station, who is incorporated by law in order to give his successors in office some legal capacities and advantages, particularly that of perpetuity, which in their natural persons they could not have had. In this sense, the sovereign in England is a sole corporation. So is a bishop. So are some deans distinct from their several chapters, and so is every person, or parson and vicar. A corporation's soul consists of a single person who is made a body corporate and politic. In order to give him some legal capacities and advantages, and especially that of perpetuity, as a bishop, dean, etc. Blacks first. Corporation, an act done with an intent to give some advantages inconsistent with official duty and rights of others. The act of an official or fiduciary person who unlawfully and wrongfully uses his station or character to procure some benefit for himself or for other persons contrary to duty and the rights of others. Co-sureties. Two or more sureties to the same obligation. Co-surety. A surety who shares the cost of performing suretyship obligations with another. Coven. A secret conspiracy or agreement between two or more persons to injure or defraud another. Black sixth. A secret contrivance between two or more persons to defraud and produce another in his right. Covenous. Deceitful, fraudulent, having the nature of, or tainted by coven. Black sixth. Credit. The credit of an individual is the trust reposed in him by those who deal with him that he is of ability to meet his engagements, and he is trusted because through the tribunals of the country he may be made to pay. Blacks first, see note. Note, credit means belief. It comes from the Latin word credere, believe, trust. It is also inextricably linked with one's name. If one examines the above abstract from Blacks first, the inherent fraudulent nature of the current credit system is abundantly clear. The only reason trust is reposed in anyone by the folks at the Federal Reserve is because an individual can be made to pay via the tribunals of the country, a type of transaction requiring no trust, with a built-in insurance policy for the con. Credit equals belief equals no substance equals Federal Reserve notes. Creditor. Creditor includes a general creditor, a secured creditor, a lien creditor, and any representative of creditors, including an assignee for the benefit of creditors, a trustee in bankruptcy, a receiver in equity, and an executor or administrator of an insolvent debtor's or assigner's estate. UCC 1-201-12. See note. Each type of representative of creditor listed above is, in itself, a precise description of secrecy of the Treasury, who is the official receiver in bankruptcy over the bankrupt U.S. government, such as describes the underling of Secretary of the Treasury, one of whom is the Commissioner of the Internal Revenue. In law, the most senior form of codified law on the planet is the UCC. There are only two kinds of people, debtors and creditors. The same is true in any statutory court. Judges and attorneys are also included in this definition. Creditor, per the Internal Revenue Code, also means employer. See note at employer. All right, and that's it for the C's. We'll start on the D's next time.